Today, I'm going to start fundamental rights. Right? We'll talk about fundamental rights. What fundamental right is, how it works, why it was there, why such kind of fundamental rights, what are the features which have been adopted in India. Right? We'll talk about that. If we see that during the ancient times, the focus was actually not on rights, it was on duties. These are the duties. King has said this, you have to do this. But in Europe during the Middle Ages, around 1200, 1100, 1200, there was a chaos in the society. King John, I think 14 or 14 was there. I think 14 was there. He was the king, and there was a big rebellion being planned among the population because of his, in fact, dictatorial way of ruling. So somebody suggested him to give rights to the people because they are clamoring about rights. They want rights. They don't only want responsibilities. They don't want themselves to be treated as animals. You are treating them as slaves, as animals. Please give them certain rights, ensure certain rights. So a Magna Carta, a document named Magna Carta was prepared. And this document, right, this document, Magna Carta, gave certain rights. Actually, certain rights were given, some basic rights that they can walk on road, they can walk with their family, kind of lot of basic rights were given. Human rights are abstract formulations which can be traced to religious and moral philosophies, right? There are a lot of human rights, basic rights, right? Those are, in fact, abstract formulation. Why we are calling it abstract formulation is the things which are not seen, which are not well defined properly, right? So rights were there, but they were not well defined. Magna Carta did one thing, that they brought in one page all the rights actually which are basic to human, right? These were already there in the religious and moral philosophies, but people were not entitled to use that. This codification and enumeration of these rights allow them to develop and give rise to human right laws. Slowly and gradually, these laws got enumerated, codified, written in one book, right? During 1600, we can say that 1686 or something, British government brought Bill of Rights. British government, not US. I'm not talking about US. You must have heard about Bill of Rights of US, right? But British government, for the first time, taking cue from Magna Carta, brought certain Bill of Rights. Those were actually proper fundamental rights being defined for the first time. They were in fact discussed, but implementation was very weak there, could not implement those rights. Later on, the US Constitution became the first constitution which provide this right, because in between these two incidents, like 1685 and 1776, in between these two incidents, you will find French Revolution did take place. And in French Revolution, the first and the foremost thing which was demanded was liberty. Liberty means freedom. Freedom means having rights, right? So this liberty principle, which was being propagated during those days, human liberties, those human liberties were enumerated later on in Bill of Rights, and those Bill of Rights are known as Magna Carta of actually human rights. In India, for the first time, this demand came from Motilal Nehru Committee, which says that in India, we should have certain laws like Bill of Rights of USA. That was way back in 1928. Getting it? During the Indian national movement, this idea of right was further sharpened and expanded to constitutional rights. Later on, they demanded that not only Bill of Rights, this Bill of Rights should be inculcated in the Constitution itself so that it could become a constitutional right. Got it? Yes or no?
Yes, sir.
Yes, sir.
Our Constitution, in fact, focused on fundamental rights, and they said that this is the crux or the core of our Constitution. They focus in that the main purpose of the Constitution is not only deciding who will govern and how they will govern. It is also very important to decide that those who are governed, their rights are protected. Their rights are protected. For that, our Constitution reflected this long tradition which started with the Magna Carta in 1215. And we got inspired from Bill of Rights of America. And from there, we in fact derived most of the rights, but we have customized it, modified it into our system, right? Getting it? So fundamental right is mentioned in your Constitution. It is mentioned in Part 3 of the Constitution. Part 3 of the Constitution from Article number 12 to Article number 35. Borrowed from US Constitution. And it is also known as Magna Carta of India. This is Magna Carta of India. Now you know why Magna Carta, because Magna Carta is now used as a proverb for, in fact, all those important documents which are very necessary for the nation, for the, we can say that Lakshmikant, reading Lakshmikant in polity is like Lakshmikant has become Bible, or Lakshmikant has become Magna Carta of polity, right? Which was not there earlier, right? So Magna Carta means very important document. Fundamental rights are enjoyed by whom? They are enjoyed by individuals, right? But some are also available to non-citizens too. That means fundamental rights are available to citizens as well as non-citizens. First thing, this kind of questions they do ask. The main purpose of the fundamental right is it acts as a limitation upon the powers of the state. The society came together and gave its powers to the state actually. The state can become dictatorial. The state can manipulate the lives of the human. So there should be certain kind of restriction on the state so that state does not violate the basic rights of the human being, right? This was aimed to prevent the state from becoming authoritative in nature, authoritarian in nature. In other countries, rights of protection available against the state, but India, even against the private person. Means these rights, which are known as fundamental rights, are available against state. That means they are vertically available against the state. If state violates my rights or state is unable to protect my rights, I will go in the Supreme Court and file a case under Article 32 that this state, this government is not protecting my right, or this government is trying to snatch my right. So this is available against the state. If an individual violates my fundamental right, in most of the countries, the fundamental right are available only against the state, not against the individual. But in our country, as we can see in Article 17, Article 17 is a right against untouchability. If we say that if a person is treating somebody untouchable, even that person can file a case on this person who is treating him untouchable in Supreme Court directly. Means the remedies are available to private individual against the private individual as well as against the state also. Getting it or not? That means it is available against the state as well against the private individual. Means available vertically and available horizontally also. Example, right against untouchability, right to freedom of movement, right against exploitation. These are the rights which are available even against the private individual. Not all rights, but these are the rights which are available against the private individual. Right? They are justiciable. Its fundamental rights are justiciable. This is the most important point. If somebody violates my fundamental right, I will go in the court. Means these are defended and guaranteed by the Supreme Court of India, which is called as the guarantor of our fundamental rights. Article 32 talks about remedies. If your fundamental rights are violated, Article 32 says that you can directly go in the Supreme Court and file a case, and the Supreme Court will issue a writ or the order, written order against the government or the individual who has violated this. These fundamental rights are negative obligations on state. What is the meaning of negative obligations on the state? Means state have to ensure that these laws are not violated. Suppose there is an IPC or Bharatiya Nyaya Sanhita. IPC, Indian Penal Code, the old law, and the new law, Bharatiya Nyaya Sanhita. These laws are to be protected by whom? Us. That we should not violate those laws. हमें चोरी नहीं करनी है. We should not do hit somebody. We should not do illegal activity. Right? हम नहीं करते हैं. If we are doing, who will punish us? The government will punish us. Right? So that law, those laws are negative on us. But for fundamental rights, if the government is not protecting my right, who will be sued? Government. Who will be punished? Government. Who will punish? The court on behalf of the public. Getting it? So these are negative obligation on the state. State has to ensure that they must not violate somebody's fundamental right. Most of the fundamental rights are negatively worded negatively against the state. In case of India, right also enables state for affirmative actions. Rights also enable state for affirmative action. In most of the countries, the fundamental right only limits or restricts. It limits or restricts the government not to violate the fundamental rights. But in India, it not only limits the government, but it also asks the government to do something. Means not to do means not to violate, but also to create something, to do something, right? State for affirmative action means positive rights. You should create certain environment for certain people, certain kind of people, right? There is omission also, and there is commission also. You have to omit certain thing, not to do something, and you have to do certain things, that is commit certain things. The government is there to protect your rights as well as create certain measures for certain class or category of affirmative actions, like for women, children, SC, ST. Fundamental rights are not absolute. This also a kind of question is there. Is the fundamental right absolute? You will say, no, it is not absolute. Absolute means limitless. Is the fundamental right limitless without any restriction? You will say, no, they are not absolute. They are actually qualified. The state can impose certain kind of restrictions on them. That you said, I have right to freedom of speech. And you are saying that I will speak anything to anybody. You are defaming somebody, abusing somebody, creating nuance on the society, right? So freedom of speech does not allow you to speak anything. You should speak under certain limit. This limitation, when it is put, this is known as reasonable restriction. The restrictions should be there. Government can put restrictions, but the restriction should be what kind of? It should be reasonable. It should be very fair. It should not be unfair and unjust restrictions. Right? Who will decide that it is fair or not? It is just or not? This is to be decided by the courts. Supreme Court and High Court has the right to decide that restrictions imposed by the government through laws should be reasonable enough. This point is understood by all, I hope. How
Yes,
it is
sir.
not absolute. If you feel any kind of confusion, you can, because these are laws, right? Polity is a different subject. It is different from all other subject, I say. It is different from science, it is different from history, it is different from geography, in the sense that it has certain terminologies. And those terminologies can mean lot, they have lot of meanings. Those meanings are to be explained. Those meanings are to be understood. They may create confusion. You might be seeing that every time there is a constitutional case, the Supreme Court takes very long time to decide. Even Supreme Court gets confused lot of times on the wordings of the laws. They are made intentionally so that it encompasses majority of the aspect on that issue. So the words used were very finely designed, and they may create certain kind of confusion. But we need to clear the confusion at the highest level when we are talking about constitution. So that the standard, there are the words which may mean something else. But the standard which is created by constitution and the courts, we need to understand those. Then only we can get the grip on these kind of papers. Right? These fundamental rights are sacrosanct or permanent. Yes or no? These are not sacrosanct. Not sacrosanct means these are not permanent, untouchable. You cannot touch this. This should remain always like this. No, it should not be like that. They are changeable. They can be modified. But by whom? By Parliament, only through Constitutional Amendment Act. Only through Constitutional Amendment Act CE. Most of them are directly enforceable, means they do not need any supportive law to be made by Parliament to implement them. They are directly enforceable. Fundamental rights are self-enforcing, but some of the fundamental rights need certain kind of laws, backing by law, to be enforced. Like the law which is said right against untouchability. Right? This does not enforce itself directly. It needs certain kind of law to be made by the Parliament, which will allow the enforcement of this provision given in the Constitution fundamental right. Right? The fundamental rights are also meant for promoting political democracy. Right? Yesterday we talked about DPSP. There we talked more about social and economic democracy. They ensure more social and economic democracy. Right? Actually, today, so sir talked about standardization of the class in a very streamlined manner. So I am using the PPTs here so that a standardized write-up can be given to you. You can understand and write it from here. This PPT may be supplied to you also. I will send it to sir after the completion of the full topic. When full topic is complete, I will send it to you so that you can take revision also, and you can take help from this, right? Secondly, those who are not able to write properly simultaneously, actually write those things which we are discussing in between the class, right? You can write the highlighted part, the yellow part, which are marked here. This page, you will find all the lines. but this is not the case in every page. Only write the highlighted part and the things I am writing on the board, right? Those things you will not find uh, further, right? So DPSP is a socio-economic democracy, while fundamental right ensures a political democracy. Politically, everybody is equal, everybody is enjoying the freedom, everybody is right having their own way of way of living, right? Next. We can divide these fundamental rights into first generation rights, second generation rights, third generation rights, and fourth generation. When we say first generation rights, those are the rights which were initially given in the Magna Carta. Those are very necessary rights, like civil and political right. That is civil and political right, like right to liberty. Later on, it was added into that. Right to life, freedom of speech, right to speech. These are the, in fact, rights which are first generation rights. Initially, these rights came into politics. Second generation rights is socio-economic rights, right to equality, right to work, right to education, right to food, right to shelter, roti kapda makan. These came later on. These are the second generation rights. पहले बोलने का अधिकार. I should speak. I should. I'm not animal. I'm human being. I have my own opinion. I have my own expressions. I should be allowed to live a life. My life should not be, in fact, in the hands of somebody else, right? So those are the first generation, right? Then comes the roti kapda makan type, right to equality and right to work and all those things. Then comes the third generation, right? That is collectivity, brotherhood, fraternity, right of sexual minorities, means women, right of ethnic and religious minorities, consumer rights, right to differently abled people, right to clean and healthy environment, right? These are the third generation rights. India is very efficiently, India has almost given the first generation, second generation, and third generation rights in the fundamental right itself. Fourth generation rights are also coming up slowly and gradually through the court cases. Right of future generations, right? The sustainability, right? Right to environment is what? Right of future generation. Right of exploration of cosmic space, sustainable use of global commons, net neutrality, right to internet as a basic human right. This has come already. Net neutrality is there. Sustainable use of global commons. This is, in fact, not entered in our fundamental rights yet, but it's basically there, right? This has also not come into our fundamental right, but basically it is there. This right is also coming up slowly and gradually as we are constitutionalization of the environment is being done. As the constitutionalization of environment is being done, these rights are coming up very fast. Originally in the constitution, there were 7 fundamental rights. Now we have 6. There were 7 fundamental rights. Right to equality, mentioned in Article 14 to it. Right to equality. Then you have right to freedom, 19 to 20. Right to freedom, 19 to 22. Right against exploitation, 23 and 24. Then you have right to freedom of religion, Article 25 to 28. Then you have cultural and educational rights, mentioned in Article 29 and 30. Right. Then you have right to property, which was there in Article 31, but actually it was deleted by 44th Constitutional Amendment in 1970. Though it was neutralized quite earlier, in 1951 only it got neutralized quite a bit, but it got deleted or removed by 44th Amendment Act in 1978. Then you have right to constitutional remedies, Article 32, which is there. So these are the 6 rights which are available, except for right to property, all are available now. Right to property is removed from the list of fundamental rights. Now it is no more a fundamental right. It is a constitutional right mentioned in Article 301 of the Constitution. Got it? There was a question. What are the fundamental rights which are available only to the citizens, not to the foreigners? Exclusively for citizens. These are the rights which are available exclusively. for citizens. Article 15, 16, 19, 29, 30. Right? Right to equality of opportunity. Right? Right to equality of opportunity, Article 16. Then you have right against discrimination. Right against discrimination, Article 15. Discrimination. Then you have right to freedom, we can say, right to freedom of speech, association, assembly, movement, residence, and trade and profession. Right? We will talk in detail about these rights. Right? 15 is right against discrimination. 16 is right to equality of opportunity. 19 is right to freedom. 29 and 30 talks about cultural rights, cultural and educational rights. These are the rights only available to the citizens. The rest of the rights, like mentioned in Article 14, right to equality, mentioned in Article 17, right against untouchability, mentioned in Article 18, right against using of titles. Then you have Article 20, 21, 22. These all rights till 32 are available to all the members who are present in India. He may be citizen, he may not be citizen. Fundamental rights available to both citizens and foreigners, except enemy alien, are 14 and 20 to 28. 14, 20 to 28. What is enemy alien? Just understand this. Like, you are the population of India, right? Population of India can be of many types. They can be citizen also. They can be non-citizen or foreigner. Non-citizen can be friendly alien. We call non-citizens as alien, friendly alien, or enemy. If you come from a country with which we are at war with, then you are treated as enemy alien. And if you come from the countries with which we have no war, those countries are friendly alien. Getting it? Apart from this, there are other category also, like refugees are there. Refugees may be legal, may be illegal. Legal refugees whom the government has given asylum are the legal refugees, and illegal refugees who had entered in India with wrong documents or having wrong documents or failed documents, those are illegal. And apart from that, a fourth category also exists, that is stateless people. Refugees must come from certain state, certain country, but the stateless people like Rohingyas, they are coming from a state which is not their own. Their state has declared them out of their state. Myanmar has declared them out of their country. They have been, in fact, denied the citizenship of Myanmar, and neither they are citizen of Bangladesh nor they are citizen of India. They are citizen of nowhere people. Getting it? So enemy aliens, except enemy aliens, most of the fundamental rights, except these rights, are available to aliens also, foreigners also. If the fundamental right of individual is violated, if the fundamental right of individual is violated, they can approach Supreme Court directly under Article 30. This is the benefit of having fundamental right action. Without 32, fundamental right was nothing, was just a document. But this brought life in fundamental right. I am giving you a lot of things, but all the rights are there. But what will happen if that right is violated? The government violates my right. What I will do? There should be certain person, certain initiative which should regulate that, punish the government, right? Give me the justice. For other rights, for fundamental rights, you can use Article 32 and go directly in the Supreme Court. For other rights, you cannot approach if other rights are violated. Like I said, right to property is now a constitutional right. If that is violated, you cannot approach Supreme Court directly, but can approach High Court directly under Article 226 of the Constitution, or you can also go in the subordinate courts if being allowed by the higher courts. Getting it? So we can see that the purview of 226 is bigger than the purview of 32, because in 32 you will only find remedy for violation of fundamental rights, and in 226 Article 226 you find remedy not only about fundamental right but also fundamental rights plus other rights. You find remedy for everything. So if the breadth of the laws are seen, Article 32 is not broader than Article 226. 226 is broader and Article 232 is narrower. While on the other hand, if we see the depth of the rights, the Article 32 give more power to the Supreme Court actually. So if we see depth wise, 32 is stronger law. If we see breadth wise, 226 is a broader law. Now let's start from Article 12. We are going to talk about Article 12 to Article 35. Article 12 gives the definition of state. Yesterday, when I was talking about DPSP, those who have missed DPSP, those who have in fact not understood DPSP preamble and the last class on making of the Constitution, on Saturday and Sunday, we can arrange certain class for that, a revision kind of class. You can take that revision from there. If you have missed that thing or you missed to understand, because initially a new subject, when it is introduced to the people, many times they are not accustomed with the rules and regulations of the subject, or the grammar of the subject is not understandable so easily. So in that scenario, I'll try to, in fact, make up with the revision so that if you are going to listen it twice, you can understand it better. In this part, unless the context otherwise requires, the state means what? State, as I define in DPSP, Article 36 of DPSP talks about the definition of state. It only says that state for this part of the Constitution will mean as defined in Article 12 of the Constitution. So let us see what is defined in Article 12 of the Constitution. The government of India will be treated as state. The Parliament of India will be treated as state. The government and the legislature of each of the states means the executive. Government means executive plus the legislature is state of the union government. Similarly, the executive plus the legislature of the state government. All local or other authorities within the territory of India under the control of government of India. All the local authorities, panchayats, municipalities, which are under the control of the government of India and are in the territory of India, they are also treated as state. The fourth concept which is given in state is actually the other authority. This one. They said that government and parliament, government and legislature, local authorities can be treated as state. But all other authorities, that is statutory or non-statutory authority like LICs, ONGC, SAIL, etc., other authorities. This is a very vague term when you say other authorities. There will be many entities which are government partially and private partially. What will happen to those, right? So a lot of debates started coming up during this discourse. When we say that other authority, the first question came, is judiciary a state? Is judiciary a state? The first question which was asked. Can we bring it? Is my to minimize the windows? Hello?
Yes,
Why it is not getting shared? I'm got it. Is it visible now?
no, sir.
No, sir.
Visible. Is it visible now?
Yes, sir.
When we say that, is judiciary a state under Article 12? Is judiciary a state under Article 12? Then the question comes, judiciary actually is not a state. When judiciary is functioning in its judicial capacity. Judicial capacity means doing judgment, the main role of judiciary. It will not be treated as a state, right? When we say judiciary in its judicial capacity is not state, always mind it. But judiciary in its administrative capacity is state. What is administrative capacity here? When judiciary is allotting cases, appointing its own staff, managing the staff, moving out the logistics, documents, constructing buildings for courtrooms, managing the electricity of the courtroom, all those are administrative affairs of the court. The administrative affairs of the court, this is state. But the judicial capacity, in judicial capacity, judiciary does nothing. It does not make law, right? And neither it has power to violate the fundamental right. It only decides on the law. You are saying X is correct, the other person is saying Y is correct. What judiciary does? It says neither X is correct or Y is correct. According to the law, Z is correct. Or according to the law, Y is more closer to, in fact, being right. Only it decides what is right or wrong. So in judicial capacity, it should not be treated as. Then another question was, is United Nation Organization, UNO, a state? Right? So Delhi High Court in 2019 declared that UNO is not a state defined under Article 12 of the Indian Constitution. Right? As per under 12, in Sanjay Bahel versus Union of India case, it says that no, it is not the state. Similarly, a question was there, is Bar Council of India the state? Is Bar Council of India the state? During the COVID time, this question was being asked, right? In the Uniform Financial Assistance Policy case, it is also known as lawyer's case. Supreme Court said that, yes, Bar Council is a state, right? Bar Council. Because to be a state, the first and the foremost requirement was, as Justice P.N. Bhagwati highlighted, that if you want to check that whether this body is state or not, you should, in fact, find out that who is the authority, who is guiding or regulating the functions of that body, who is having the absolute control over that body, who is financing the body, who is funding the body, right? is that body discharging certain kind of public service or not? If it is discharging certain public service, it is authorized or not? Suppose a person is laying road and he is a private contractor. He got the contract from PWD department of the government, and he wants to, he is building that road. And while building that road, your fundamental right got violated by him, by that person X. Will he be treated as state or not? Yes. Will he be treated as state? Yes. Till he is building the state road, he will be treated as state. If he is building a private multi-story building somewhere and certain fundamental right is violated, he will not be treated as state there. But again, when a person is functioning in the capacity of the government, they will be treated as state. In Rupa Ashok Purra versus Ashok Purra case, in this case, Supreme Court said that no judicial proceeding could be said to violate any of the fundamental rights. Means judicial proceedings does not violate fundamental right. So judiciary should not be treated as a state. Superior courts of justice did not fall within the ambit of state or other authorities under Article 12. Superior judicial bodies, when acting judicially, would not fall under definition of the state, but when it performs the administrative or the civil function, example, conducting examination, it will fall under the definition of the state. State. Now, after knowing the definition of the state, we will move to Article 13. Article 13, which talks about judicial review. Article 13 says that. Article 12 defines state. Article 13 says that हमसे जो टकराएगा चूर चूर हो जाएगा. से जो टकराएगा चूर चूर हो जाएगा. It is in Hindi. चोर चोर नहीं, चूर चूर. चूर चूर हो जाएगा. It means who will come and try to destroy me will be destroyed automatically. Any law which is made by the parliament or by any of the bodies is inconsistent with the fundamental rights, it will automatically get null and void. Article 13 says that. From here, a new question comes. Who will check that parliament is making that law correctly or not? That is not violative of fundamental right. That should not be violative of fundamental right. Who will check that? Supreme Court is given the authority and power to review the laws, right? This reviewing of law by the judiciary is known as judicial review. This concept originated in US Constitution. It is the power of higher judiciary, in Supreme Court and High Court, to declare a law made by the state as unconstitutional, that is null and void, if the law is inconsistent with one or more provision of the Constitution to the extent of the inconsistency. Jitna inconsistent hoga, utna unconstitutional declare ho jayega. It is, this judicial review is not only available against the legislative action, means lawmaking action, but also the government action, that is the executive action. This judicial review is available against the executive as well as the legislature. Getting it? This is mentioned explicitly in Article 13(2) and also implicitly, indirectly mentioned in Article 32 and 226. That court has power to do certain kind of shit. This is clear or not?
Yes, sir.
Laws inconsistent with or in derogation of the fundamental. All laws in force in the territory of India immediately before the commencement of this constitution, insofar as they are inconsistent with the provision of this part, shall be extended to such extent inconsistently void. Suppose 26 January 1950. Before this, there were certain laws, and now new law has been prepared. And it was seen that the new law which is prepared is in conflict with this part of the law, the old law. So this part of the law will become null and void after the constitution has come. Right? Similarly, the state shall not make any law. Further in future, after this date, the state means the government, parliament or the executive shall not make any law which takes away or abridges the right to that was conferred by part 3 of the constitution. If that is in contravention, that will become null and void. If today the parliament makes certain law, the judiciary can declare it null and void, right? If it is in contravention with the fundamental rights. Similarly, unless the context otherwise requires, law include any ordinance, order, bylaw, rule, regulation, notification, customs, means the word law, all laws in force, that is mentioned in Article 13, or this any law word, which is mentioned in this part of the Constitution, that is Article 13. What is the meaning of what it includes? It includes any kind of ordinance. Ordinance is the executive order which is having the power of legislature, or executive order, or bylaw, or rule, or regulation, or notification, or any law made in parliament. Any kind of law comes under this word law. Means any kind of these things become inconsistent with fundamental right, तो हमसे जो टकराएगा चूर चूर हो जाएगा, फंडामेंटल राइट से जो भी टकराएगा वो अपने आप खत्म हो जाएगा. करेक्ट? I will come to some discussions on that later on. Then comes amendability of the fundamental rights. Are fundamental rights amendable? Are fundamental rights amendable?
Yes, sir.
They are amendable. It's all started with State of Madras versus Champakam Durai Rajan case in 1951. Durai Rajan was, in fact, not given reservation in educational institution in which he was, in fact, going to take admission. So his mother filed a suit in Madras High Court, which was later, in fact, decided by the Madras High Court. But again, that was challenged in Supreme Court. The Supreme Court said that since Article 15, which gives rights against discrimination, it gave reservation for SC/STs in jobs, OBCs in jobs. But that was not specifically mentioned in Article 15 for education. Article 16 deals with job, and Article 15 deals with education, reservation in education. So this case was struck down. The order struck down government order regarding caste-based reservation in government jobs and colleges. In college seat, caste-based reservation was not allowed that time. Government promoted Article 46, but against Article 14, 15, 29, Supreme Court favored Article fundamental right, that is 14, 15, 29. Government says that in Article 46, it is mentioned that the weaker section of the society should be given special care. But Supreme Court said that is DPSP, right? That is not fundamental right. And fundamental right, Article 14, 15, 29 says that no such reservations should be given. So government brought amendment in the constitution. The first amendment 951 was brought. And in 15, Article 15, there were three clauses, 15.1, 15.2, 15.3. They added clause 4 and provided for reservation in colleges. So for the first time, the fundamental right was amended in 1951 in the state of Madras versus after the Champakam Durai Rajan case by First Amendment Act in 1951. It inserted clause 4 in Article 15. It says that nothing in this article or in clause 2 of the Article 29 shall prevent the state from making any special provision. It says that socially and educationally backward classes of the citizens should be, in fact, even the scheduled caste and scheduled tribe should be given special provisions. Discrimination is allowed because this is an affirmative action and this is a positive right that should be given to the OBC and the SC/ST people. Provided for saving laws of providing for acquisition of estates. This was another amendment. This is not concerning with the reservation, but the fundamental right, Article 31A was inserted. If the government wanted to take somebody's property, acquire somebody's large property, that is estate property, they can acquire it because right to property was in existence those days. And it also added, the first constitutional amendment also added 9th schedule. There were only 8 schedules. The 9th schedule, that is land reform thing, was also added by this amendment, and Article 31B was added. It created 3 things. 15(4), a new amendment was implemented. Then 31A was inserted, 31B was inserted. Okay? These are the 3 amendments being done by the first constitutional amendment 1950. Then the amendability question came again in the Shankari Prasad versus Union of India case 1951. It decided that Parliament has 2 types of powers. One is the Constituent Assembly power. Means the Constituent Assembly, which in fact was dissolved after the formation of the Constitution, gave all its power to the Parliament under Article 368. Now Parliament has right to create new kind of values in the Constitution. Right? Another power which Parliament have is the normal legislative power, as it makes law, right? So constituent power are vested in Parliament now. Article 13(2) says that law does not include constitutional amendment. Means the word law mentioned in Article 13 includes every kind of law except the Constitutional Amendment Act. This was decided in Shankari Prasad case. That is, no limitations on the amending power of the Parliament. Law does not include Constitutional Amendment Act. So there was no limitation on the amending powers of the Parliament. Parliament can amend everything and anything, right? In Sajan Singh versus State of Rajasthan case, this was again reiterated. But in Golaknath case, things changed. In Golaknath case, 1967, Parliament under Constitution enjoys only ordinary legislative power. Means Parliament does not include the Constituent Assembly power. This was said in Golaknath case. So that means fundamental rights cannot be amended. Parliament cannot amend fundamental right even using 368. So here a new kind of question arises, that you are saying that Parliament is only having fundamental rights, having only 368. If 368 is there, it has said that it can amend the Constitution, then why you are not allowing the fundamental rights to be amended? That means once the fundamental rights become redundant, why can't it be changed? Or new kind of fundamental rights if come in, why can't that be added? These kind of questions arise. In response to this, the 24th constitutional amendment was brought in by Indira Gandhi in 1971. It changed the title of Article 368. They said that power of Parliament to amend the Constitution and the procedure thereof. She wanted that the Parliament should have limitless power. The Parliament should have limitless power, absolute power, so that she can amend anything she wants. For that, she brought 24th constitutional amendment and did certain kind of tweaking and changing in Article 368 and Article 13. And they said that nothing in Article 13 can restrict 368. And that same sentence was written in 13(4), that nothing in this article shall apply on 368. That means 13 से अगर 368 टकराएगा तो चूर-चूर नहीं होगा. Meaning absolute power to Parliament to amend the Constitution, including fundamental right. Right? This was again challenged in court. When it was again challenged in court, then came the Keswanand Bharti case, the final destination, Keswanand Bharti versus State of Kerala case. In this case, the Supreme Court said that though fundamental rights can be amended, right? Parliament can amend any part of the constitution, including the fundamental rights, but without affecting the basic structure of the constitution. It brought the concept of basic structure. Basic structure. Actually, this concept, basic structure, was used by a Pakistani judge, Camellia, right? He used it for the first time in Pakistan in 1965. In India, in 1973, this concept was used again. This means that certain things are there in the constitution which cannot be changed. Suppose, basic structure concept, you need to understand this. Suppose your face, my face, Utsav sir's face, or many other people's face are different, totally different. But the basic structure of the face is same. Suppose in place of your ear, if your nose or eyes were implanted, will you be Homo sapiens? No, you will not be in Homo sapiens anymore. If the basic structure of the face changes, things will change. So there are certain visions, certain philosophies, certain doctrines which are basic tenets on which this constitution is built. Those things cannot be changed. And in fundamental rights, certain things are there which can be changed, and certain things are to be treated as basic structure of the constitution. This was said in the Viswanathan Bharti case. This is a judicial innovation. This was not provided by the constitution. Again, for the parliament, it was a kind of a great tussle between the parliament and the judiciary. Judiciary was trying to stop parliament to take the absolute power, and parliament was trying to take that absolute power through amendments. 42nd Amendment Act was again brought by Indira Gandhi in 1976. It added clause 4 and 5 in Article 368 to dilute the limitation of basic structure, right? But this limitation which was brought by 42nd Amendment Act was again challenged in Minerva Mill case in 1980, and Supreme Court said that these are the things you are going to bring, and to stop the court to look into the matters of the parliamentary laws. So this is null and void and unconstitutional. So both judicial review and the limited amending power are the basic structure of the constitution. It declared these two things as basic structure of the constitution. If once this is basic structure, you cannot change this now. You cannot snatch the power of judicial review. You cannot snatch you cannot increase your power unlimited. So these two restrictions were given in Minerva Mill's case. Again, this was again reaffirmed in Vaman Rao case in 1981, that basic structure is important and it should be there. Recently, there was a lot of, in fact, debate on the issue that basic structure concept should be there or not, right? Current position, Parliament can amend any part of the constitution, including the fundamental rights. This power is not absolute, it is limited power. Amendment shall not destroy the basic feature of the constitution. This is the current position of fundamental rights, amendability, and pursuit. I hope this was understood by all. From tomorrow, I'm going to start right to equality, means Article 14 to 18. We'll start Article 14 to 18. You will understand what is the meaning of equality and what is the difference between equality and equity. What the concept equality says, we'll talk about that tomorrow, Article 14 to 18, and maybe Article 19 to 22 will be finishing tomorrow. Getting it? I hope you have understood Article 12, Article 13, judicial review, amendability of the fundamental rights. Yes or no?
Yes, sir.
Yes, sir.
Is this approach comfortable to you all?